All right, so the next section that we're going to cover, and it's the last main section for tonight, is about evictions and tenant protections. Before I have Kate Waltz give her presentation, there's just a couple things I'd like to cover. We're not going to go into eviction law or procedures for pursuing an eviction, but there are a couple things I want to note here tonight. First of all, I'm not an attorney, so I can't give you legal advice on how to pursue that. But we thought it would be appropriate to bring up not only some resources on evictions, but also talk about tenant protections, given the connection with the crime-free housing program and the lease addendum that we're requiring, and the potential that you could find yourself in a situation where you would be pursuing eviction. So there's three main causes of evictions. Really, the most obvious one is non-payment of rent. You're not paying me, I'm going to issue a notice. Lease violations, which would be, or otherwise known as evictions for cause, that would be in where the lease addendum would come into play. Like, it's behavioral related. You're breaking some sort of behavioral contract. And then there's also the situation with holdover tenants where their lease has expired and they haven't moved out, and then you actually, because they have occupancy, that you have to pursue an eviction that way. There's two main laws in Illinois that you should be aware of that cover evictions. The first is the Forcible Entry and Detainer Act, and then the second, which is the Safe Homes Act, which Kate will cover in a bit. There are two resources that I want to highlight for you. The first is the Illinois Legal Aid. I always have a hard time saying this. Illinois Legal Aid Online. And they have a whole bunch of resources here, but the one, they have specifically information about evictions. They give step-by-step instructions on what would be involved in an eviction. They have frequently asked questions, and also forms and letter templates. If you haven't been through the process before, I'd recommend working with an attorney because there are many steps or procedures that you need to follow, and you wouldn't want a legitimate eviction case being thrown out of court if you miss one of those procedural steps. But this resource will kind of give you context for what the process would be. And then another resource is the Illinois Association of Realtors Practical Guide for Landlords in Illinois. I don't have the URL up here because it's a long and convoluted one, but if you Google this, you'll quickly find it. And it's a quick 101 on important laws that you should be aware of as a landlord. It covers security deposit interests, also obviously evictions, so I would check that out as well. So now I would like to formally introduce Kate Waltz from the Shriver Center, and Kate is actually an Oak Park resident, and she's graciously offered her time several presentations for us to talk about tenant protections. So thank you, Kate.
So I'm going to talk to you about laws with respect to victims of domestic violence and sexual assault, specifically as to their housing rights. First, under the Illinois Human Rights Act, the Act prohibits discrimination on the basis of order of protection status in real estate transactions, including rental transactions. And so if a tenant would receive an order of protection and provide it to a property owner, and the property owner would say words to the effect, "I don't want any trouble, and you need to leave because I don't want any trouble," that tenant could file a complaint with IDHR or go directly to court. It is considered discrimination in Illinois. I'm also going to talk to you about the Safe Homes Act. The Safe Homes Act is a law that's been in effect since 2007 to enable victims of domestic violence, dating violence, sexual assault, and stalking to end their lease early if there's a credible imminent threat of violence against them on the premises, or if they're a sexual assault survivor and there was a sexual assault on the premises and they're asking to leave within 90 days of the assault. They're also able to ask for and receive an emergency lock change. All types of private housing are covered regardless of size. So if you're leasing out a single-family home, you would be covered. Tenants who participate in the Section 8 Housing Choice Voucher Program are also covered by this law. Tenants who live in project-based Section 8 housing are also covered. Residents in public housing are not. The reason for that is that if they leave their housing, they lose their subsidy. So there are other laws that I'll talk about that protect them. For a victim of domestic violence, dating violence, sexual assault, and stalking, as I said, they have to allege that there's a credible imminent threat of future harm against them on the premises, and that they provide the property owner or manager a written notice within 3 days of vacating the apartment. No further additional proof is required. I've been asked as sort of what's a typical example. One of the most sort of common letters I've seen from victims to their property owner is, my husband attacked me. I called the police. He was arrested, but he's getting out of jail in 24 hours, and I need to leave. And so I'm ending my lease early so that I'm safe. And so that's sufficient proof, and as long as that victim is sending the letter within 3 days of legally vacating the unit, they've complied with the law. For sexual assault survivors, the State House also recognized that they may need to leave even where there isn't a credible, ongoing, imminent threat of harm against them on the premises. So they can send a 3-day notice within actually 90 days of the assault or as soon as practicable. Third-party proof in that instance is required. So a police report, a letter from a victim service organization where they're receiving services, a medical report will be sufficient third-party proof. Again, the sexual assault survivor does not need to show the imminent threat. If the landlord would still pursue this tenant for the remaining rent due under that lease, the tenant could assert their proper use of the Safe Homes Act as an affirmative defense. This provides no defense to the perpetrator, and so this does not terminate the perpetrator's lease if the perpetrator is in the home. Under the Safe Homes Act, a survivor can also seek an emergency lock change. If there's a written lease and the abuser is not on the lease, the request must be in writing from all tenants who are parties to the lease and must allege that it's due to a credible imminent threat of violence against that victim on the premises. It also must be accompanied by one form of evidence, a medical, court, or police evidence of the violence, a police report, or a statement from a victim service organization from where the tenant is receiving services. If the abuser is on the written lease or there is no written lease, it's an oral lease, then there must be a written request from all the tenants except the perpetrator and must be accompanied by a plenary order of protection or civil no contact order providing exclusive possession of the premises to the victim. The landlord must change the locks within 48 hours of the written request or give the tenant permission to change the locks. If the landlord does not respond, the tenant can either go to court and seek a court order to change the locks or change the locks on their own. The tenant is responsible for the cost of the lock change, and both parties are required, whoever changes the locks, to tender the new key to that party within 48 hours. Landlords often ask me, how many locks do I have to change? Under the law, they're only asking you to change the lock to the immediate unit for that tenant. They are not asking you to change all of the locks in the building. You may still want to do that for safety purposes, and you should talk to the tenant about that, but legally you're only required to change the immediate lock to the tenant's apartment. Under the Forcible Entry and Detainer Act, the state's eviction statute, victims of domestic violence, dating violence, sexual assault, and stalking also have an affirmative defense in an eviction case if the eviction is based on the victim's status as a victim of domestic violence or sexual assault, based solely on an incident of actual or threatened violence against that tenant, and the case is solely based on the criminal activity related to that domestic violence that has been perpetrated by a member of the household or guest of that tenant. It's also that if the case is based on a violation of the bar order and that tenant did not let that barred person on the premises, this is also an affirmative defense. So in many instances, we have seen where a landlord will bar the abuser from the premises. And if you understand the cycle of violence, that abuser may not stop. And we know that from press reports recently, unfortunately, where that abuser will not stop, and they will continue to try to threaten and physically harm that tenant. And so they will re-enter the premises. So the basis of the last provision is to make clear that is not the victim's fault. If they are not permitting them onto the property again, it is the perpetrator who's violating the bar order, and this tenant would then have, in that instance, an affirmative defense. The landlord can overcome the affirmative defense if he can show that the tenant's continued occupancy would pose an actual and imminent threat to other residents, the landlord, or the employees at the property. The landlord can also evict the abuser only. When we drafted this provision of law, we made that point because we were continuing to hear from property owners who said that they had attempted to only evict the perpetrator, and the courts were saying you must evict the entire household. This clarifies it that you can evict the abuser only. The landlord also has a right to bar any individual not in the household as long as they provide notice to the tenant and notice to the barred individual. Are there any property owners here tonight, before I get into this section, who participate in federally subsidized housing programs like the voucher program? Okay, so I'll go through this part quickly. This is the Federal Violence Against Women Act. These provisions that I'm going to talk about protect victims of domestic violence, dating violence, sexual assault, and stalking who live in most forms of federally subsidized housing. And so you'll see the list of housing that's covered. The most common for private property owners will be the Housing Choice Voucher Program. So there's a admission protection for victims of violence, that you cannot deny admission to them on the basis that they have been or are a victim of violence. And you cannot terminate or evict them as a result that they are a victim of violence or for crimes directly related to the abuse or for an incident of actual or threatened violence. Similar to the state law, you can evict if the lease violation is not based on those acts of violence, or if you can demonstrate an actual and imminent threat to the other tenants or those employed at providing services to the property if the tenant would stay. The threat must be real, would occur within the immediate time frame, and could result in serious bodily harm. The owner can also what's called bifurcate the lease, essentially to split the lease into two and then to take steps to just evict the perpetrator only and to prioritize maintaining the victim's housing. As I said previously, Illinois law also allows for this. If the perpetrator is the only household member who is eligible for the federally subsidized housing program, the housing provider will give the victim time to establish eligibility for the program. Congress has made it clear the priority here is that victims of violence retain eligibility for housing programs and retain their ability to live in those housing programs and do so safely. There are certain proof requirements associated with this. You can either take the victim's word for it, you can ask them to sign a VAWA certification form that's created by HUD, or the victim can provide, not at your behest, but on their own, police, court, or administrative records, or a statement from a third party, such as a victim service organization. These statements must be signed under penalty of perjury. If you have any questions, I'm happy to answer them, and thank you for being here.
No questions? Any questions? Thank you, Kate. All right, well, we're on the home stretch here. Just a couple words about a potentially new property maintenance code that the village is looking at adopting. So currently all property maintenance codes, which are basically standards for existing buildings on how they should be maintained, are included in Chapter 12, which is the housing chapter. Just as a note, if you're ever interested in looking up any of the village's codes, they're available on Sterling Codifiers. So if you Google Sterling Codifiers Oak Park, you'll pull that up and you can read all sorts of interesting village code. So our plan is to adopt the 2009 International Property Maintenance Code with some minor amendments to reflect some Oak Park particulars. This International Property Maintenance Code is written by the International Code Council, which basically is a standard organization for building codes throughout the nation. Recently, within the last 2 months, the village adopted a series of building codes that govern major rehab and new construction. And so this is the cousin maintenance code to those recently adopted codes. So our plan is to bring this to the board in early 2015. And the benefits really are that we'll be modernizing the language over time. We've been adding to the code. It's been kind of locally written, and so there's some inconsistencies or lack of clarity in certain areas. So this will really just add a lot more, clarity to if there are situations where we need to issue citations. I don't think that there will be much difference that you would see if you have multifamily properties that are being inspected, or when we're inspecting your small rental properties from the exterior. It'll just be better communication from our end when you get notices from us. Are there any questions about what this would entail? Seeing none, no questions there. I just want to flip to the last page so you have an opportunity to write down any of our contact information. Again, Cedric Melton, his door is always open to help you resolve tenant disputes, as is the door or cell phone for Officer Murphy. We have the information up there for Commander LaDon Reynolds and Sergeant Dave Jacobson, who's the head of the Community Policing Unit. And then, of course, myself. If you have any questions about development customer services, about property maintenance, our grant programs, please let me know, and I can get you to the right place within the village. Any lingering questions about anything we covered tonight? Oh, let me run up there and get you the microphone.
So I just want to make sure that I understand kind of what the process requirements are for all of this. So I haven't filled out. I have a single condo unit that I rent out. So I didn't get any kind of application before. So tonight I could pick up an application, I could fill it out, give my check for the payment for it. Then at some point I would get in the mail a copy of the license. So then what is the renewal or notice process? I mean, so will that be something like, will the village send out an annual renewal notice? So
correct, yeah, we would send out an annual renewal notice, at which point if you're still renting the unit, then you would renew, and if you're not, you can send us back evidence that you've sold the unit or that you've moved back in, or, just so that you wouldn't be renewing the license at that point, if that's the case.
And will the renewals be, kind of like the, the vehicle license on here's the period, or is it on a rolling basis? So if I become a new, let's say, or, will it always be, I guess, December of every year that I'll do it, or is there some kind of
Yeah, the intention is for us to try to do these in one set period every year. I can't say it'll be December or November next year, but it most likely will be in the fall that we'll start sending out the renewal notices. There's some people that, because this is a new program, aren't getting licensed until maybe stragglers, early part of 2015. So some of those individuals might be a little bit later in 2016, or we haven't made an administrative decision on that, but I think generally we think it'd be easiest if we have a set period of time where we send out all the notices to people.
Okay. And then I guess I have one other question regarding the lease and application requirements. And I guess to my knowledge, what I recall, I think that I have all of this information either on my application or the lease, but this is saying all information should be on all leases and applications. So does that mean that even if, like in my lease, I reference like this application, whatever you put on your application, it applies in this lease? Or are you saying that even on my application, I need to put all of this information as well?
The information should be on both documents.
Okay, so all of the stuff about the parking prohibition, the units, that needs to be on the application?
Yes.
Okay.
Any more questions out in the field? Wait.
You mentioned annual renewal will come to you in mail. How do you update your mailing address as a landlord?
Oh, if you want to, well,
If I move, where do you mail that information?
that is a good question. So the information that's at the bottom of the license application, that's the office within the Village of Oak Park that you would contact. It's the housing programs. You can also email housing@oak-park.us, and then that information would get to us that way. We are moving toward a software system that will allow us to handle licenses even online. So hopefully this time next year this will be integrated into an online platform. No guarantees on that, but we are moving in that direction. So doing updates about your property, doing registrations should be easier moving forward. But for the time being, you can either send a notice to us here in Village Hall, to housing programs, or to email housing@oak-park.us.
When I came in to apply for the application, I asked if this training was required every year. And I know in your presentation it was mentioned that only if your house becomes like a nuisance. So I was wondering if the training is still required every year, or is it going to be only if it's a nuisance property?
No, so the training per the ordinance is required every year, or every 12 months. There might be additional training beyond this kind of 101 type seminar that could be required by the chief of police if it is a nuisance, but it would be something completely different from this. So yeah, this annual management seminar is something that we've done for multifamily property owners, the 4+ unit owners for many years, and then that's the expectation that we would have for now all rental property owners.
And there was also talks about having online training, is that correct, in the future?
That is correct. Yeah. We have one more question over here.
Will these slides be made available to us, or will that just be included with the online training? Or
Yeah, so that is a good question. So will the slides be available? If you want them now, send me an email, and I'll shoot that over to you, a PDF of it. We will be putting this online with the video and all our handouts as well. So if you're not that anxious to get it, then sometime in January, it'll be up online. Last call for questions. All right. Well, thank you so much. You guys have been a great crew. Thank you for participating. We really appreciate it. Any questions pop up about these different issue areas, please don't hesitate to contact any of us. Thank you.